Thank you, Sheila. Our first speaker this afternoon, I heard about 20 years ago, I think, thereabouts, something like that. And she was speaking on the topic of ladies in waiting at a college in Iowa. And I happened to just be there that weekend to hear the talk. And since then, of course, over the last couple of years, I've even gotten to know her much better as I have worked with her and for her as treasurer of the National Spiritual Assembly of the Baha'is of the United States. She is a judge on the Ninth Circuit Court of Appeals of the United States and former treasurer, as I mentioned, and currently chairman of the National Spiritual Assembly of the Baha'is of the United States, and has been on the National Spiritual Assembly some 19 years. She is a graduate of UCLA Law School and has a master's in law from the University of Southern California, where she was professor of law, the first woman professor of law, from 1957 to 1980, and was dean of that law school from 1967 to 1980. Her primary area of expertise as an educator has been the improvement of administrative justice, of the administration of justice, and she has authored a textbook in that area. She and her husband, James Nelson, created and sit on the board of the Community Dispute Resolution Center of San Gabriel, California. And she has been active in numerous organizations and associations, legal and otherwise, over her long career. This afternoon she will be addressing our conference, and we're very honored and pleased to have her on peaceful conflict resolution, some exciting developments. I present Judge Dorothy Nelson.
Thank you so much, Ivor. I must say, over the past couple of years, an example of peaceful, loving conflict resolver is Ivor Stokely. And what a pleasure and a privilege it's been to have him as a colleague in the office of the National Treasurer. As I've been listening to these wonderful talks, I've changed my talk about 5 times. And then I go to lunch and I meet someone who says, I'm not a lawyer and I have no connection with the justice system. Do I really belong here? And my answer is, you belong here more than those lawyers that Ivor is trying to get rid of. So, what I'm going to do, with apologies to some of the Baha'is who have heard some of these things before, because we have a new and somewhat new and quite a diverse group, you might hear some of the same old thing again. But if you get bored, I want you to look at my artwork over here, especially the face. That is a smiling woman who is looking at you, and she is going to be key to part of my story today. I'm going to take you back to India just year before last, when I got off the airplane, was surrounded by the press, and asked about Bhopal. This was after the terrible escape of gas, the Bhopal incident, and I had been preceded 3 weeks before by a San Francisco lawyer. And when the San Francisco lawyer got off the plane and they said, what are you doing here? He said, M-O-N-E-Y. Now, I knew that's why he was there, but I was very surprised that he said that to the press. He said, Judge Nelson, what would you do about Bhopal, an incident where an international corporation had been guilty of something, perhaps, thousands of people killed, thousands of people injured, and still dying? I said, I think it's very simple. I would do what the International Court on Human Rights does. I would have an international fact-finding commission. I would have them bring the facts back and bring the parties to a table to mediate the dispute. And after the facts have been presented, I would go around the room and ask each person involved what his or her version of the facts was, and then what his or her solution to the problem was. And if that didn't work, I would take it to international mediation or perhaps to the international court. I tell you this because of the 3,500 newspapers in India, 722 carried a story. Mediation for Bhopal, says U.S. judge, which was illustrative to me of how the people of the world are hungering for a peaceful, non-adversarial way, if you will, to resolve conflict. Indeed, in India, it takes 20 years to get to court in a civil lawsuit. Bill Davis knows because he's traveled Sri Lanka, India, and around the world. And so they look to the Americans to find a better way. But if this American lawyer does win in 20 years, or even 5 years, or 10 years, the millions he promises his clients, most of them will be dead, and most of them would have been very happy to have received $500 a month for life, to live in the style to which they were accustomed, and to receive the medical treatment that they really needed. And so we find in this country something that should cheer the heart of a Baha'i. I'm going to refer to the principle of consultation in the Baha'i faith. This should be the subject of a conference, but it's the basic principle. It's a very powerful political principle, not a partisan political principle, a powerful political principle by which the problems of the world, of the family, may be resolved in a peaceful manner. And happily, the peoples of the world are beginning to catch on a little bit about what consultation is all about. Now, it's not true Baha'i consultation. They have true Baha'i consultation. You submit yourself to the will of God, and you turn to the laws of God as your point of reference. But the beginnings of this kind of consultation are very important. And I go back to Chief Justice Berger, who now has been replaced by a new Chief Justice, but his constant thing was, our current adversarial system is too costly, too inefficient, and too destructive to solve the problems of mankind. And again, with apologies to those who've heard this before, it's still one of my best illustrations of what has bothered Jim and me in the court system. When I was on sabbatical, my first sabbatical leave in 1965, I was a relatively new Baha'i. I tried to think of a way to get to Israel. I thought, I'll study the laws of marriage and divorce. No one's done that. And the laws of Israel, the laws of the East pertaining to family law, all are religious. So in Israel, if you have a marital problem, if you are a Jew, you'll go to the rabbinical court. If you're a Christian, you'll go to one of the Christian courts. If you're a Muslim, you'll go to the Sharia court. If you're a Baha'i, you will go before the Baha'i administration. And Jim and I one day went over to Akka, right across in the Bay of Haifa, to watch a divorce proceeding in a Greek Orthodox court. Little old Quonset hut, paint peeling off the walls, hard table in the front of the room, 3 hard chairs, about 8 chairs in the audience. 3 Greek Orthodox priests came in, long pointed white beards, long black robes, sat down. The presiding judge announced that this was a proceeding for divorce. He would begin with the wife. The lawyer for the wife stood up with a whole bunch of blue back papers. The presiding judge said, "No, sir, let me hear from your client, the wife." "Oh, honored sirs," she said, "I must have a divorce. I've been married for 7 years, and although I love my husband, I cannot continue to live this way. We are very poor. We live in a house with 1 room on the first floor, 1 room on the second floor, with 1 entrance to the house. My mother-in-law lives on the first floor. Every day when I go out, I have to go right by that front door, and she asks, 'Where are you going? What have you bought? What are you doing? Who did you see?' She said, 'I cannot live this way.' The presiding judge turned to the other side and said, 'Let us hear from the husband.' The lawyer started to get up with his blue back papers, and the presiding judge said, "No, let me just hear from the husband." And he said, "Oh, honored judges, I love my wife. I don't want a divorce. But I'm a good Christian. I must take care of my mother. I am poor. I cannot afford two houses." Whereupon the three judges marched outside, stood in the dirt, came back in 5 minutes. Their solution, the husband was to build a ladder to the second-story window, and the wife was to climb that ladder. Jim and I looked at each other and said, what would have happened to that couple in the Los Angeles Superior Court? A marble palace, plush chairs, there would have been orders to show cause, there would have been long delays. The couple probably would not have walked out hand in hand, smiling at each other while the lawyers sort of glumly went out. But they probably would have walked out their separate ways, paying lawyers' fees for the rest of their lives. And the family law area is just but one area that is not being dealt with properly in our court system. And part of it is the adversary system. My former colleague on the bench, Marvin Frankel, wrote a wonderful book called Partisan Justice, where he very strongly criticizes the adversary system. He says there is too little emphasis on truth-telling. Last night when I was talking about there's no privilege against self-incrimination in the Baha'i faith, when we go before a local assembly, we're expected to tell the truth. He says, there are other goods, but the greatest is winning. There are other evils, but scarcely any worse than losing. Those of you who have indicated to me you've served on juries, when a lawyer is trying to select a jury, is he trying to get the most impartial jury of his peers? His whole purpose is to find the most biased lawyers to vote for his side. In fact, one of our magistrates just wrote a wonderful article on the adversary system, and let me just quote briefly. His name is Wayne Brazil. The means employed by litigators to achieve victory for their clients regularly involve manipulating people and the flow of information. This manipulation may involve not disclosing evidence that could be damaging to the client or helpful to an opposing party, not disclosing persuasive legal precedents that could be damaging to the client, undermining or deflating persuasive evidence and precedents by such means as unsettling or discrediting honest and reliable witnesses, or by burying adverse evidence under mounds of obfuscating evidentiary debris, overemphasizing and presenting out of context evidence and precedents, pressuring and cajoling witnesses, jurors, and judges, deceiving opposing counsel and parties about the weaknesses of the client's case and the strengths of opposing parties, aggravating and exploiting possible vulnerabilities of the opposing party and counsel that have nothing to do with the merits, and so forth. Now, this is quite an indictment of the justice system and quite an indictment of lawyers. And, of course, not all lawyers do all of those things. But under our current code of professional conduct, all of those things are permitted. And so we find around the world, and especially in the United States, a search for alternatives. And there are the reasons of cost and delay and so forth, but the ADR movement, and I should have put this on the board, is the hot movement, Alternative Dispute Resolution Movement. This does not mean that these alternatives are necessarily instead of a court system. The court system is very necessary in certain kinds of cases, and I'll mention that in just a moment. But people are concerned about the delay, about community participation, about access to justice and the like. And so we've had all sorts of remedies suggested. My own law school, we had the father of preventive law, Lewis M. Brown, who said we don't do enough in law schools to teach people how to get their clients to avoid conflict. to avoid trouble. And so we ought to teach law students how to write contracts and trusts and wills and so forth so that conflicts will not arise. We don't teach law students enough about legislation that could prevent conflict. Now, we adopted no-fault divorce in California. It was mentioned this morning to reduce the number of conflicts in terms of divorce proceedings. But each time we do, say we adopt no-fault auto insurance, you have to constantly evaluate what you are substituting in place of what you're getting rid of. But one of the most exciting concepts in the United States is the whole concept of what my friend at Harvard, Frank Sander, calls the multi-door courthouse, but I call it the multi-door justice system. And in Tulsa, in Houston, in Washington, D.C., there are experiments taking place with the multi-door justice system, and one experiment is about to take place in Los Angeles County. In these multi-door systems, you have a terrible problem, one close to your heart. And instead of trying to look around to see what you might do, you might go to your lawyer first, or you might go to the multi-door courthouse and meet a smiling paralegal at the door. And I say smiling because as we're planning the multi-door courthouse for Los Angeles, we had some architecture students from USC go out and talk to people in legal aid offices about what kind of an office they would like to have. Do you know what the vote was for? A fireplace in an office. Everybody said if there were a fireplace, even if there weren't a fire in the fireplace, that they didn't like to come into places that were cold and had steel and had a secretary staring at them while they were waiting to see the lawyer. You would give your problem to this well-trained paralegal assistant, male or female, which we are now training at the USC Law Center, and you might be referred to an ombudsman. Suppose you have a bad washing machine, suppose your television set breaks down. The model is the Swedish Public Complaints Board, where in Sweden, if you have a complaint now that's below $1,500, you go to the ombudsman, who's paid for by the state. The ombudsman investigates the situation and tries to get it remedied, has no legal power. If the situation can't be remedied, and you can prove your loss, that your TV tube isn't working, your television won't work, your washing machine won't work, the ombudsman will pay you by check, but enter you in on a little computer for a possible future class action of a whole bunch of people. And then what they do every Friday night, the Swedish Public Complaints Board goes on television and says, we would like you to know the facts about the XYZ washing machine company. They do not make good on their warranties. It is amazing that in Sweden there is 85% compliance with the Swedish ombudsman. But suppose you don't want to go to the ombudsman, you might be referred down the hall to a mediator. Now, the mediation model is the family model. Instead of the judge way up here, the disputant way down here, the mediation model, in the words of Professor Lon Fuller, seeks to bring people together. And in Sunday school, we talk about consultation. My husband doesn't let me sing in public, so I won't sing it. But basically, consultation means finding out what everybody is thinking about. You listen to them, and they listen to you, and then you all do what most of you want to do. It's a basic model for mediation. In our Community Dispute Resolution Center just 3 weeks ago, some John Muir High School students and the police. At our mediation center, we have developed mediation materials based a lot on this book by John Tolstoy, teaching students how to mediate their own disputes among themselves, with their teachers, teachers with administrators, and the like. And the students, using these mediation skills, met with the police chief and 3 of his assistants. The police chief came out just shaking his head. He'd never seen anything like it. The students said the police were harassing them after school, stopping them when they had no reason to be stopped, not letting them speak in groups, not letting them meet on corners. It went back and forth and back and forth. And the students proposed a plan to the police chief which he said it was so good I couldn't turn it down. And he walked out, he said, what a powerful tool that mediation is in the hands of students. And instead of violence, instead of sit-ins, instead of strikes, this ability to mediate disputes. And it takes me back to New York a few years ago when Columbia Law School was beginning to train lay mediators, lawyers not permitted. And where do they come from? We started with the Junior League in Pasadena to get volunteers, and we have branched out to many people who are tired of bridge clubs, who are retired, who want to come and make a contribution to the justice system and totally volunteer their services. And the example in Brooklyn was a group of black-jacketed youth who were arrested for vandalism, disturbing the peace, public nuisance in front of a record shop. They were given their choice of a public defender going to court or coming to the mediation center. As they sat around the table, I sat on the side and watched them. And one of the employers, the man who owned the record shop, brought two other owners of shops on either side. They said, why don't you blankety-blank kids get a job? Sir, are you offering me a job? Why, we have been looking for jobs in this neighborhood for months. Well, why don't you kids go home and play their records? Why do you have to come in and scare away my clients? Sir, would you like to come to my home? I live on the 11th floor of a tenement. I have 9 brothers and sisters. We have 3 rooms. The point of all this was, at the end, there is now, in the basement of a bank building in Brooklyn, a youth recreation center. There are 250 businessmen who contribute $10 a month toward that center. Guess who runs it? The youth of the neighborhood. And so what mediation has brought about, instead of sending the kids down to juvie, as we call it, juvenile hall, the juvenile court, and putting them out of sight and out of mind, the community is beginning to become involved in finding long-term solutions to some of these very pressing problems in the community. Suppose mediation doesn't work. By the way, you ought to know about mediation. You can have it in your living room. You can have it in a bank building. You can meet in the park. You can have it in a drugstore. You don't have to wait 20 years. You don't have to wait 5 years. You can also say, I want the mediator to leave the room. And mediation is not second-class justice, as has often been claimed. In fact, when I was dean of the law school and I sat on the board of Southern California Edison, I recall a time I was their first woman member of the board of directors, and I was going to be very quiet and silent, but we had a dispute with a major corporation. Our downtown lawyers came in and said, this is a very complex case. We will file litigation immediately. It will take approximately 5 years to get to trial. Approximate cost, $200,000 a year. A year. They left the room, and I raised my hand. I said, Mr. Chairman, that's $1 million. He said, yes, litigation costs are very high. I said, why don't we call them up? Why don't we have a corporate officer come over along with the lawyer? We'll give them an hour, and we'll take an hour. I said, well, why not? I wouldn't tell you unless it had worked. At a total cost... We see the corporate officers had the bottom line in mind. They didn't care about winning the case. They wanted to settle it. They wanted to move on. And it cost about $57,000 to do that, lawyers and sending documents back and forth. And I thought that was too high, but compared to $1 million, it wasn't that high. But this whole concept now has been formalized in what is called a mini-trial system. It's not really a trial. There are lawyers who don't want to be engaged in the adversary system. And if you pick up the legal newspapers, they advertise their services. Some of them are rent a judge, some of them are rent a mediator, some of them rent a person to run a mini trial. And for a certain charge, they will bring the people together, get them settled, get everything going, and begin to settle disputes. But what is more impressive was 3 months later, when we had the same problem with the same corporation, instead of filing a lawsuit the minute they did it again, we called them up and said, hey, Joe, you're doing this again. And they said, oh, we better look into this. We're sorry. We'll look into it. Now, note, we didn't do away with lawyers. Lawyers don't get too nervous yet. Another 100 years, I think lawyers are going to have to get nervous about litigation, except for criminal litigation, but I'll leave that to another day. But suppose the parties cannot resolve the dispute. And part of mediation, of course, is designing a remedy that you can live with and they can live with. And when you design your own remedy, as you know, when you consult with your children, and your children suggest what might be the appropriate remedy in a case, they're much more likely to follow it, obey it, and it won't happen again. But you might go on to some form of adjudication. This might mean an arbitrator. Now, I have in my court cases that sometimes involve 30,000 documents, complex documents dealing with check kiting and all sorts of things. And when I get the, 6 feet high volumes of depositions and all the record on appeal, and realize that a jury has listened to all of this, and maybe after 6 months is supposed to come up with what is right and what is wrong, some juries may do all right. But what business people are finding and community people are finding, that sometimes it's better to find someone who knows something about the business and have both sides agree that this person is qualified to handle this kind of arbitration. In the Baha'i faith, some of you may not know that the National Assembly often uses an arbitrator in a situation that is very complex. It might be a business dealing between two Baha'is. The non-Baha'is ought to know that as a general rule, Baha'is come to their local assemblies when they have legal problems. They're not prohibited from going to court, but they come to the assembly, and the assembly sometimes mediates the dispute, or the assembly may select a well-qualified arbitrator to help the parties come together. You may not want to have an arbitrator. You may wish to go on to court, and one of the new happenings in the court system today is a summary jury trial. Judge Lambrose of Ohio concluded that a lot of people come to court because they just want to see what a jury might do. And so what he does, he calls in 6 regular jurors. Summary presentations are made by each side. A couple of hours on each side, the jury goes out and says, we would hold for so-and-so, not knowing they are only advisory. And then the parties usually go out and settle. There are some criticisms of the whole system, but you should know that every statistic shows that alternative forms of dispute resolution mechanisms are growing rapidly. I looked at the American Bar Association's 1986-87 directory of nationwide dispute resolution programs. It is 376 pages long. It has almost 400 dispute resolution programs in 46 states, and these are the kinds of programs that Baha'i lawyers or Baha'i laypersons who would like to be trained as lay mediators might want to find out about. There are a number of publications out now. I thought I brought 4 of them along. I brought only 3. Dispute Resolution, which is a journal put out by the American Bar Association. Dispute Resolution Forum, which is put out by the National Institute for Dispute Resolution. The Negotiation Newsletter, which is put out by the Harvard Law School. It's interesting that over half of these programs began less than 8 years ago. And if we look around the world now at what is happening, you can see that it's becoming very, very popular internationally. Now, one of the most exciting programs is at the Harvard Law School, which several summers ago began bringing 6 Soviet diplomats to meet with 6 American diplomats to learn the art of consultation. Most diplomats are taught that they should go in and win. And if they don't win and don't bang their fists on the table until they win, they are fired. And what this program has done, and I would like to think it might have led a little bit to Glasnost and what Gorbachev is doing now, has taught these international diplomats really how to listen to each other, how to let go of their opinions, how to devise a solution or a remedy which is better than any single proposal offered by either side. Now, if you look at the Pacific Rim territories, I'm hiring a young man that has a famous name next here. His name is Nicholas Rockefeller. And I didn't learn until I came today that his fellow Yale law student of Baha'i had sort of prepped him before he came to interview with me. And in my interview with him, I interview about 320 young, bright law graduates we choose 3 clerks. He knew so much about the Baha'i faith, and I thought it was marvelous. But he talked in the Pacific Rim area about dispute resolution centers that were being run by Baha'is, offering mediation services, arbitration services, everywhere from Pohnpei to Sydney, Australia. But if you look around the Pacific Rim in particular, you find all over Australia, you find New Zealand in particular. We now have the Inter-American Commercial Arbitration Association. Stockholm has what they call the Chamber of Commerce that mediates and arbitrates. There is the London Court of Arbitration. The American Arbitration Association works all around the world. In 1985, the United Nations adopted a model law on international commercial arbitration, and it is now being followed in 58 states and worked through 18 international associations. Well, what happens in the States? You know, Professor Owen Fisk of the Yale Law School is very critical of the alternative dispute resolution movement. He said what is wrong with it is, number one, when you have an informal dispute resolution, there is no precedent set for the future. And there may be cases in which you need a precedent set. Laura Nader of Berkeley has criticized the Dispute Resolution Center as taking the poor man out of the court to get rid of him, when indeed there should be a court decision. For instance, one of the examples given by Professor Fisk is in the busing situation in the South. If you had had mediation with local people, you could have ended up with majoritarian tyranny saying, we don't need busing, separate but equal schools are just fine. And I give these examples to say that mediation and arbitration are not for all kinds of cases. I look at Sam Conrad, who is a supercar dealer, and I suppose General Motors puts out a car with very bad brakes. And General Motors runs into the Community Dispute Resolution Center of Pasadena and says, oh, we'll mediate this dispute. We'll be very happy to pay this person off. We would be inclined to say, no, we think this dispute ought to go to court. Unless you're willing to enter into a consent agreement that will be published nationally that all defective brakes throughout the nation are going to be repaired. In environmental cases, the tobacco industry sought to have mediation of a number of its disputes in various counties and territories. And most of the dispute resolution centers said, no, these are the kinds of cases that ought to go to court. We have a national policy now that needs to be established. But as a matter of fact, in the Baha'i faith, when you go to a local assembly, we don't have to worry about things like busing or racial problems or injustice and majority tyranny, because we have our own solutions within the faith. But until we all ascribe to the spiritual standards of the faith, I think that we're going to have to be very careful that we don't let majoritarian tyranny take over. But I was just looking through some of these recent magazines and found that in Hawaii, they just used the art of consultation to mediate their water code problem, which has been going on for 17 years. In Boston, just a couple of months ago, they decided a public housing issue that had been going on for 12 years. They brought in all the parties concerned, listened to all the parties involved. In Minnesota, they settled a 10-year-old forestry dispute among various parties, both public and private. And in New Jersey, just last month, they settled a problem of jurisdiction about who gives emergency services. But as my time is running out, I'd like to say that one of the most exciting areas where the whole idea of peaceful resolution of conflicts is having an impact is in the field of education. It was way back in the 1960s when I went to visit in Boston, and I met with a school superintendent, and we began talking about the discipline of children and the increasing violence in the schools. He said, well, we have a solution for that. We have a large stock, and he said, we buy them by the gross. They're called rattans. They're switches. And he says, we maintain order in our Boston schools. Every single teacher is taught how to use the switch. Now, I began to look into this, and I found that the official public school curriculum in Boston called for students to memorize a homily which included the words, quote, "The good child obeys out of love. The wicked child obeys out of fear." The child who did not learn to memorize this homily was promptly hit with the switch. Now, in addition to the obvious contradiction, the hidden message these and many other children learned is that by threatening violence, you can influence or force others to behave as you want them to behave. Today, these children are adults. The rattans or switches are nuclear bombs. And another generation has learned that violence and power are the way to deal with differences. With modern weaponry, the question now becomes, how often will history have a chance to repeat itself? Now, as at Justice Newman's suggestion at our peace conference, we got a pocket edition of the Promise of World Peace. And if you reread this, it says very clearly that to bring about the peace of the world, it will come about through an act of consultative will, and either after unimaginable horrors or through our coming together in an international convocation using the principles of mediation. Now, although our schools may have unintentionally contributed to the ethic of violence that threatens our world, there are subtle but significant signs that a new ethic based upon the principles of consultation may be developing. As our other schools across the country, that same Boston school system that once provided each teacher with a regulation switch is now training students and teachers in the skills of non-adversarial dispute resolution. John Holt, the author of How Children Learn, writes, "True education doesn't quiet things down. It stirs them up. It awakens consciousness. It destroys myths. It empowers people." There are now a growing number of educators who are beginning to believe that children are not truly educated if they are not prepared to deal with the disquieting but empowering nature of peaceful resolution of conflicts. Conflict is a natural part of life and is neither good nor bad. The peaceful expression and resolution of conflict is a powerful learning tool that the child can use lifelong in settling disputes within the family, within the community, within the nation. It is especially useful when you're dealing with cross-cultural differences. And indeed, in dealing now as the Pacific Rim is opening, conciliation and mediation are the ways of Asia. Frankly, when people come from China and Japan to resolve their disputes in this country, they are aghast at our court system and the way in which it works, and the thousands of interrogatories and discoveries and depositions, as we call them, where you inquire about what's happening. And so, particularly as we begin to be and recognize ourselves in a global society, the whole art of consultation becomes very, very important. Lastly, I'd like to say that there are a number of Baha'is around the country dealing with these issues. Down in Pasadena, we have a brand new courthouse, the Vista del Arroyo Courthouse, for my Court of Appeals, north of which are a number of bungalows, which we are now converting into places for research and development in peaceful means of resolving conflict. We have a house that's dealing with law-related materials for primary and secondary school children, one was dealing with the multi-door justice concept. I have Dean Carrington coming out from Duke University, who's going to work with several of us out here on our whole concept of alternative forms of dispute resolution. So I would just like to say to you, both lawyers and non-lawyers, if any of you are interested at all, I'd be very happy to supply you with more information. I have 2 minutes to take questions before my better, shall I say my better half, my better whole, or the whole of my half, whatever proceeds. Let's take a question.
How come I can't get major insurance companies to mediate this?
The question is, how come I can't get major insurance companies to mediate and arbitrate disputes? Thousands of insurance companies are mediating and arbitrating disputes. In Los Angeles, we have the Intercompany Arbitration Association handling most personal injury and property damage disputes in the county of Los Angeles. I might add, when I served on the board of Farmers Insurance Company, they were not thinking along those lines, but they have found since that time enormous amounts of money saved by companies mediating and arbitrating disputes between and among companies, and leaving the lawyer out. Not always. Sometimes the lawyer comes in and presents a given side, but then it's immediately mediated or arbitrated. And we have lots of information on that. If you have a particular company you'd like to introduce to this, I'd be very happy to assist you. Ron.
How do you enforce some of these?
All right. Enforcement is a very interesting question, and the United Nations, several United Nations commissions have taken this up and have found some very effective ways to put in the agreement that if there are differences under the agreements, it will be referred to X, Y, and Z, other arbitrators, mediators, and so forth. So you can put in enforcement mechanisms. The United States, in terms of public disputes, has not always been willing to put in those enforcement mechanisms, but more and more with the intervention of United Nations agencies, we're finding that, in fact, I know of no arbitration dispute in the past couple of years dealing with, say, international fishing problems, dealing with all sorts of problems. I know of no dispute where the award of the arbitrator has not been complied with. So it's a very helpful sign. There are many in our own American Bar Association who think arbitration is fine for our country, but you can't trust those other guys over there. And so they don't want to enter into international commercial arbitration agreements. But one of the little bungalows, by the way, at our Western Justice Center in Pasadena is going to be dealing with international commercial arbitration. The Society is going to have an office right there. Yes, Mrs. Newman.
How do you circumvent the barriers that the lawyers have put up against paralegals or legal assistants, against their illegal practice of law, which might be a solution to some of the conflicts you're talking about?
What a wonderful question. The question is, how do you put up with the barriers some lawyers put up to the use of paraprofessionals to assist with some of these problems? I might say when the whole concept of alternative dispute resolution first began to gain prominence, I might say at the USC Law Center in 1959, we had a dispute resolution center, but no one paid much attention at that time. But as these alternative mechanisms began to come into play, particularly with laypersons involved, some of the bar associations began to bring lawsuits saying that these mediators were engaging in the illegal practice of law. We still have problems in some states. The first step that we took was to define specifically what lay persons could do. And that was agreeable to most bar associations, where we would set out they could help bring parties together, but they could not give legal advice. In the field of family mediation, it's a particular problem because oftentimes well-meaning family mediators give advice, particularly to the woman, about what she ought to do in this family problem. And it may turn out that she has lost some of her legal rights as a result of taking the advice of the mediator. At the Harvard Law School, the first one to do it, they are now going to offer a master's degree in family mediation to the graduating law students who want to engage in mediation kinds of careers, so that they will have the legal background as well as the social science background. But you pointed out, Franny, still a very sticky problem in some states. Texas is one state where the bar is adamant about restricting what paralegals can do. But we train paralegals in the law school at USC, much to the disgust of some of my former faculty, feeling that if lawyers and paralegals were trained side by side, they would know what the skills of the paralegals might be and know when they might be employed and not feel threatened by the use of laypersons in the system. One more question. Yes?
Could you comment on the practice of justice worldwide? And I was thinking particularly of a very sad story I read a few years ago that the tribal justice system in Kenya had been replaced by a modern adversarial system because the tribal justice system was one of arbitration and mediation and it didn't really mean to, and coming up with solutions within the community.
Well, this is what is so much fun about traveling around the world. I know in Hawaii, where they recently have had great success with these systems, the Chief Justice Lum, and I'm trying to look for his quote, when some of the lawyers were objecting, he said, we're just going back to our old native practices of koho, moho, nuno, I think it is, which is let's consult, if you can believe that. I was in Nairobi in 1978 at the Criminal Justice Institute there, where we were talking about, the line then was that most things don't need to go to court. But in Kenyan, you had, there were most tribes that were run by men, and the chief said, off with the head, off with the head. There were a few that were run by women, and if the woman said, off with the head, it was off with the head. What we needed to substitute in the place of this, quotes, tribal system was a system of consultation so that all parties might be heard, that all grievances might be brought to the table, and then a joint solution found. But we have a lot to learn from other systems. For instance, Native Americans, the Navajos, they have a system of tribal justice, never throw anybody into jail. They always, no matter how serious the crime over which they have jurisdiction, assign the defendant to community service. It may be 1 year, it may be 2 years, it may be building fences, it may be doing other things, but the person never leaves the community. Is always within the supervision of the community. It's not the person leaves and then has to come back and be reintegrated. The minute that the remedy is met, that the punishment has been fulfilled, that person is accepted as a member of the community. And plus a lot of good and useful things get done. Thank you all very much for your attention.